Hi everyone, in this video we're going to be looking at Amann Aviation, Commonwealth and Amann Aviation, which is one of our key cases on reliance damages. So in this case it essentially lays out some of those principles around not only contract damages generally, so it reaffirms the, compensation principles, sorry. Just had a moment there. So it reaffirms the compensation principle, but on top of that, it also shows you the relationship between expectation losses and reliance losses and when it's appropriate for reliance losses to be the measure of a party's damage after breach of contract. Remembering that expectation losses are the standard method of calculating. So what would the party have received had the contract been performed, okay? And reliance losses are, for example, wasted expenditure. So that is a little bit further removed from what the party would have got had the contract been performed, which is why expectation losses are your primary measure of damages. But in any case, this case outlines the principles around when reliance damages may be the appropriate measure of damages. Don't know if I've confused you yet, but it will all become clear. Okay, so in this case, Amann had a contract with the Commonwealth to provide surveillance flights. When the time came for performance, they weren't ready to perform. I think they only had something like 7 out of 11 aircraft fully fitted out and ready to start doing these surveillance duties. The Commonwealth terminated the contract, and they did so in breach of contract because they didn't actually follow the extensive termination clause in the agreement with Amann. So because of that action was treated as a repudiatory breach, which then meant that Amann had a right to damages. The question became what the appropriate measure of damages was. And the reason why this issue was key here was because Amann had spent a significant amount of money fitting out these aircraft to do the surveillance duties. So much so, in fact, that if the contract with the Commonwealth had been performed, they actually would have been operating at a loss, okay? But, so they didn't want the expectation damages, obviously, because that was only a small amount of money and only a portion of what they'd spent fitting out the aircraft. But the reason why they had spent so much money fitting out the aircraft was that there was a possibility of contract renewal. And in the contract itself, there was an option for renewal. So the chances of the contract being renewed was actually quite high, and it would have been in the later contracts, so the ones subsequent to this first one, that they would have made back their money and then they would have started to make a good profit. Okay, so here there was a question of whether they could only recover their expectation losses, that is the profits they would have expected to have received under the contract, okay, or whether they could have recovered that extensive fit-out fee, those extensive wasted expenditure, those reliance damages. Now, it was held in this case that the reliance damages were appropriate, okay, because the expectation losses were uncertain. And the reason being is that there was that contract and there was that option to renew. So because it wasn't certain whether they would get the renewal or not, you couldn't say with any certainty what the losses were. And so because of that, it was appropriate to look at reliance damages. And then when you were assessing the reliance damages, you just had to look at whether those costs were reasonable. And here it was found to be reasonable. Therefore, Amann Aviation was able to recover their wasted expenditure. It was something like 6.6 million, I think it was, that they were able to recover as reliance damages. Okay, we'll go through the case reading guide and all the key aspects of the reasoning now. All right, so going through the first question. So why was the Commonwealth's termination of the contract with Amann a repudiation, notwithstanding the fact that Amann themselves were actually in breach? And this is because, as I mentioned, the contract itself set out an extensive clause around termination, and it actually also expressly took away the ability to terminate on common law grounds. So it took away the ability to terminate on grounds such as this, with Amann just being late. And because they failed to comply with the requirements of the contract in this respect, their behaviour was treated as a repudiation of the contract. Another thing to keep in mind was that at this time, Amann's breaches were not breaches that entitled the Commonwealth to terminate. So they were not a breach of an essential term, and they were not breaches that deprived the Commonwealth of the substantial benefit of the contract. Okay? All right, so looking at the second question then, so as at the 12th of September, what expenditure and liabilities had Amann actually incurred? All right, now this is where I said it was about over $6 million, okay, in performing the contract. So there was $5.2 million on the purchase of the aircraft and about $900,000 on other expenditure. So that'd be changing the aircraft, fitting it out, plus $113,000 for the security deposit to the Commonwealth. So quite a substantial amount of money there. So I think that's about 6.2, 6.3. I'm not very good at maths, but it's substantial, okay? They spent a lot of money. All right. The next question is, what gross revenue would they have earned if the contract had been performed? Well, they would have earned a gross revenue of 17 million or so. However, there would have been significant further expenses in performance of the contract, which is why the contract itself, as I mentioned before, wasn't actually that lucrative in the sense that that first contract they were going to be operating at a loss for that first contract period. So their gross revenue was 17 million roughly, and the expenses for performance was around 15.8 million. So their net profit at the end of that first year, just on their operating expenses, was 1.4 million. But remember that they've already spent over 6 million to fit the aircraft out and purchase the aircraft. So it was 6 point whatever million minus, and then they would have got back about 1.4. So they would have been down about $5 million. Okay, so that's why it was so important to them that this case was assessed on a reliance damages basis, not an expectation damages basis. Okay. How does this amount compare? So that $1.4 million, how does that compare with the amount it claimed as damages in the proceeding? Well, it doesn't, because they weren't claiming their expectation loss for the duration of that first contract. They were claiming $6.6 million, which was their total expenses in fitting out and purchasing the aircraft, their wasted expenditure. Okay, had it been performed, would Amann have made or lost money on the contract? They would have lost money, about $5 million. Just figured out. So, in terms of going to the reasoning, so what does the court say is the general rule for assessing damages for breach of contract? You can see this at 80, where the court says, and this is a quote, where a party sustains a loss by reason of a breach of contract, they are, so far as money can do, to be placed in the same situation as if the contract had been performed. So that is a straight up statement of the compensation principle in contract. In terms of the next question, the court notes that contract damages are often described as expectation damages. How does it explain the meaning of this term? This is pretty straightforward. So the award of damages for a breach of contract protects a plaintiff's expectation of receiving the defendant's performance. Okay, their expectation damages, what did the plaintiff expect if the contract had been performed? Okay. The second part of that question, it also notes that expectation damages are often described as damages for loss of profits and what's comprehended by the term profit in this context. This shouldn't be understood as carrying the implication that no damages are recoverable in a contract in which no net profit would have been generated or the amount of profit cannot be demonstrated. So if performance of a contract would have resulted in a plaintiff recovering costs, that plaintiff is entitled to damages equal to those costs. In terms of the next question on my slide, so what is the corollary of the general rule for assessing damages for breach of contract? Okay, so the plaintiff is not entitled to be placed in a superior position to that which they would have been in had the contract been performed. Okay, so you can't give the plaintiff more damages than what they would have expected under the contract, because if you did, that would amount to overcompensation. Okay, so So you can see here the tension starting to arise potentially between reliance losses in this scenario, because if reliance losses are given, that's more than what the party would have received under that first contract term. But you need to remember that reliance damages aren't seen to offend the compensation principle in this case because of that option to renew. Okay, so there was quite a high likelihood that the contract would have been extended. Therefore, the expectation is not just the expectation for that first contract, it's the expectation of that contract plus future contracts. And I think one of the judges said it was something like an 80% chance of renewal. Okay, but anyway, that's part of the reason why expectation losses are seen as uncertain here, and therefore why reliance damages were seen as an appropriate measure. We'll get to this. All right, so in terms of the next question, what do we have here? So what did the Commonwealth argue was the maximum amount a man was entitled to recover? Of course, they went with the expectation loss calculation here as opposed to the reliance loss, the wasted expenditure. So they said they were only entitled to those profits as if that first contract period had been performed, which was that 1.5 million. In terms of the next question, so on what basis did Amann claim its wasted expenditure? I don't think I've actually got this on this slide. No, I've got one. There you go. There's one more question. On what basis did Amann claim its wasted expenditure? They claimed the wasted expenditure on the basis that the Commonwealth had the onus of proof to establish that such expenditure would not have been recouped even if the contract had been fully performed. So if this onus is not discharged, the plaintiff is entitled to reliance damages, which in this case was wasted expenditure. So that was Amann's argument. In terms of the next question, does the court accept the proposition that a plaintiff has the right to elect between claiming reliance loss and expectation loss? No. Okay, so it's not an election per se. So you can't just look at your contract and say, okay, wasted expenditure gives me more damages than my expectation losses, therefore that's the one I'm going with. Okay, there's no election. Okay, instead, both of these things, both expectation losses and reliance losses, reliance damages, are seen to be manifestations of the same principle, that damages should place the plaintiff in the position, same position as if the contract had been performed. Okay, so both measures are seen to be will sit under that compensation, general compensation principle. However, note there's obviously principles around when wasted expenditure or reliance damages are the more appropriate measure of loss, which is what we're doing in this case. So next question, on what basis does the court state that wasted expenditure is recoverable? It's usually only when the plaintiff has not suffered a loss of profits or where it's not possible to determine the outcome if the contract had been performed. Okay, and you can see that at 85. In terms of the next question, so putting to one side for the moment the issue of whether the loss prospect of renewal of the contract was compensable, whose argument appears to be closer to the mark? And that's in terms of the compensation principle, I mean there. Well, you know, I think it depends. The court obviously felt that the reliance losses here didn't offend the compensation principle, but I am guessing that maybe some of you, most of you, might think that the Commonwealth's position that the expected, monetary expectations of that first contract would be the appropriate measure of damages. It seems to be measurable, even though, the second you bring in that chance of renewal, things start to go a bit pear-shaped. So I suppose if there was no chance of renewal, the expectation losses would definitely be, more in line with the compensation principle. So the Commonwealth position, but there is a chance of renewal here. So yeah, that's purely hypothetical. All right. If the plaintiff claims damages for expenditure, what will it ordinarily be required to prove in order to recover? So the plaintiff, like once it's determined that wasted expenditure or reliance losses are the appropriate measure of damages, all they have to do is prove that the expenditure was reasonably incurred. Okay, and here, I mean, even though it was a huge amount, it was reasonably incurred because they had to convert these aeroplanes. They had to buy the planes and they had to convert them to undertake this very specific task. But it wasn't just like they were going out burning money just because they felt like it. Okay, they were actually executing their side of the contract. So the next question, so what then does the defendant have to prove in order to avoid or reduce its liability for wasted expenditure? So in this instance, the defendant has to prove that the expenditure would not have been recouped even if the contract had have been fully performed. All right, and then here there's that issue with the renewal. So what is full performance? But we'll leave that aside. Oh yeah, and the reason why I said that is because obviously if there had been that renewal, then eventually Amann would have been operating at a profit. They would have recouped. The expenses. Okay. The question about does this rule apply to a purely aleatory contract, which is a very great word. Does it apply? No. An aleatory, I don't even know if I'm pronouncing it right. This type of contract is dependent on a contingency or chance. So it only comes into being if a specific thing happens, okay? So the presumption then is that the parties would not have entered into the contract without the prospect of recovering expenditure. That doesn't apply here. Because obviously if it was purely aleatory, why would a man take the chance that future condition wouldn't come into play? So why would they take the chance and spend all that money to only get back $1 million like that? So yeah, just doesn't make sound business sense. In terms of the next question, what did the Commonwealth argue in relation to the proposition that the prospect of renewal of the contract should be factored into an assessment of a man's loss? You can see this at 90 in the judgment. So here it was argued that it should not be a factor because the Commonwealth was under no legal obligation to renew. Okay, which seems, I mean, maybe, but it does ignore the fact that the chance of renewal was incredibly high. This is an incredibly specialised contract, incredibly specialised operation in terms of the surveillance. So it's not easy for the Commonwealth to just switch providers. And yeah, the court stated that it was something like 80% chance that the renewal would have happened. So what was the court's response to this argument? Well, they didn't accept it. All right. So what is the rule in Hadley and Baxendale? And that rule is essentially the rule of remoteness in contracts. So where the plaintiff is entitled to recover such damages as arise naturally from the breach, which is the first limb, or the second limb, or such as may reasonably be supposed to have been within the contemplation of both parties at the time they made the contract. Okay, so essentially what that means is losses naturally arising. So they're the losses that arise like literally from the terms of the contract. Okay, and then the other one, the losses that arise that are within the contemplation of the parties. That's to do with the special surrounding circumstances. Now, is the defendant liable to compensate only for the loss of benefits promised under the contract? No, because of that second limb. Okay, so the benefit may be something that wasn't promised, but it was within the contemplation of the parties at the time the contract was made. So in terms of the next question, how did the court assess the value of the chance of renewal? So here you can have a look at the Mason and Dawson joint judgment. And Mason and Dawson didn't put a value on it, so the chance of renewal. Rather, they just said that there was a strong prospect of renewal and then the onus was on the Commonwealth to demonstrate that the value to a man of the prospect of renewal of the contract, when combined with the expenses that would have been recovered by way of gross receipts, was less than the total expenses to be, this is a very long sentence, I'm sorry, was less than the total expenses to be incurred by a man in the performance of the contractual obligations. And Justice Brennan agreed with this analysis, and you can read more at 113. Okay. According to the Commonwealth, how was the prospect that the contract might have been lawfully terminated to be taken into account in assessing a man's loss? Okay, so the Commonwealth here submitted that even though they didn't terminate according to the contract, they may have done so. Okay, and they wanted the losses discounted based on that. So they submitted that damages should be discounted in accordance with the prospects of valid termination. Doing so, they argued that the Commonwealth would have acted so as to minimise its liability. Okay, and they submitted that there was a 50% chance that they would have terminated correctly or according to the contract, and stated that the court should therefore discount the damages by 50%. The court rejected this argument, and Mason and Dawson in their joint judgment agreed with the full court's estimation that the chance of termination was around 20%. Okay, as mentioned, and that as this was less than the balance of probabilities, damages should not be discounted at all. So because it's less than that 50% chance of loss, therefore it doesn't count, essentially, it doesn't factor in. Now, the Commonwealth complaint claims that its argument was supported by the Mahalis Angeles case, which is the least burdensome rule. So if you're interested in that, you can look it up. Now, and that was, as mentioned, that least burdensome rule means that the person is assumed, or the plaintiff defendant is assumed to act in a way that actually secures their interest in the best way, i.e. they would have terminated validly. They would have acted in that least burdensome way. Now, Justice Brennan and Justice Dean distinguished the Mahalis Angeles case, and Justice Brennan argued that the principle that the party will not act so as to increase their liability. They'll act in a way that will decrease their liability, the least burdensome way. Justice Brennan argued that that principle applies when it's found that the relevant events, as at the date of the acceptance of the repudiation, were predestined to happen, but there was no indication of that in this case. You can see that reasoning at 114. And Justice Dean notes that the power of the termination was vested in the Secretary, and it was not a power that was exercisable by the Commonwealth. Okay, so that's just to do with the construction of the termination clause. All right. Now, what probability was assigned to the judges to the prospect of lawful termination? So as mentioned, 20%, which fell short of that 50% threshold. Therefore, there was no discounting. Was this chance factored into the assessment of damages? All right. Now, each of the judgments has a slightly different position on this. So as mentioned, Justice Mason and Dawson said no. So they said it was under the 50% balance of probabilities, therefore there's no discounting. Justice Gaudron, also said no, but for the reason that where damages are for wasted expenditure, there should be no reduction for contingencies. Okay, so it's because this is a different type of damage, different type of loss, there is no deduction. Justice Dean said, yes, damages are to be reduced by 20%. And this application, when you have a look at the Silverbrook case, it's a Silverbrook approach, which is essentially in Silverbrook, it was argued that when you have loss of a chance damages, once you've proven that there was more than a 50% chance of the damage occurring at all, you then look at the hypothetical probability of the future event, and you discount the damages accordingly. So if there was a 5% chance that the person would have that opportunity, then the damages are reduced down to 5% of the total value of the opportunity, if that makes sense. So here, Justice Dean has discounted for a contingency, okay, which is normally seen in expectation losses, not reliance losses. You'll see Silverbrook, it'll make sense, trust me. In terms of the other judgments, Justice Toohey said yes, and here the damages were reduced by 50%, and the reason 50% was chosen was the combined contingency of termination of 20%, and also Justice Toohey reduced the damages for the possibility that the contract wouldn't have been renewed, and then settled on that figure of 50%. And Justice McHugh said yes to reduce the damages by 20%, so went with the Justice Dean approach. And then Justice Brennan said no, there should be no discounting. There was no onus on the Commonwealth for reliance damages to prove that the net value of the benefit would be less than the expenditure incurred, and therefore the Commonwealth had failed to discharge this onus. So where does that leave you? All right, if you've got a question like this in the exam, you would need to consider the availability of contingency discounting, okay, for wasted expenditure. So what you would do is essentially lay out options. So the first option is the joint judgment of Mason and Dawson, which is that when it's less than the balance probability is less than 50%, there's no discounting. But that infers if there's a higher than 50% chance, there will be discounting. There's the option that of Justice Gaudron, which is where damages are for wasted expenditure, there's no discounting at all. And then there's the Justice Dean approach, which is similar to the loss opportunity calculation method, which is an expectation loss. The Justice Dean approach, which is that you reduce by the contingency amount, which here was 20%. Okay, so I think that just about does this.